Hi, how's it going, everybody, and welcome to the Debutify podcast, the premier e-commerce podcast brought to you by Debutify. I'm your host, Alex Bond, and joining me today is Anita Marr, the founder and CEO of Trademark Angel, an international trademark registration agency that helps Amazon and e-commerce sellers get trademarks to protect their products against counterfeiting and fraud at a lower price point than large legal firms. Anita has over 20 years of trademark and copyright law experience and has been a registered trademark agent since 2008. She received the Canadian Education Foundation Prize for the highest results on the trademark agent examination in 2008. On this episode, Anita and I discuss the difference between copyrights and trademarks, when to file for a trademark, overall advice about trademarking, and much more. Here's our interview now. Anita, welcome to the show.
Yeah, hello, Alex. How are you?
Wonderful. I'm wonderful. Thank you for asking. Before we get any further, Anita, why don't you tell me a little bit about your company, Trademark Angel?
Yeah, absolutely. So I'm a registered trademark agent and I'm the founder of Trademark Angel. I have been working in the area of trademarks since 99, and I have been a trademark agent since 2008. I also got the highest mark in the Canadian qualifying trademark agent exam in 2007. I opened my firm 6 years ago, and we primarily work with Amazon sellers, entrepreneurs, people who sell online, small businesses. And we help our clients register trademarks in many countries, including US, Canada, European Union, China, Australia, Mexico, and some other countries. And today we'll talk about trademarks and why entrepreneurs need them, why they're important, what to do with them. Primarily, we specialize in trademark registration and some copyright registration as well.
That's great. I'm curious before we get started, and for my education and for maybe our listeners' education, if you don't mind differentiating copyrights versus trademarks, because I think they kind of get conflated pretty often.
Yeah, absolutely. So trademarks, patents, and copyright are all intellectual property. Patent protects an invention. So, for example, a new engine or an improvement to an existing invention. Most patents today are improvements to existing inventions. Copyrights protect original literary or artistic works. For example, songs, music, plays, books, photographs. And trademarks protect the name of a product or like the name of a service that you offer. So a trademark is called a brand in the business world, and it's like the shortcut between the product and the company name. It's how your customers, your clients remember how to find your products, basically, nothing more. So it's the name of your product or the name of your service. It can be the same as your company name. It doesn't have to be. It's just like a short form of how your product is identified, how it can be found.
Why is the proper reason that business owners need to register their trademark?
Well, there are many reasons to register a trademark. Actually, there are so many benefits. It will take some time to describe them. But I think one of the most important benefits that's like not immediately obvious is that when you file a trademark, it becomes immediately visible in the trademarks office database. So when other companies or other entrepreneurs pick a name, they check the database and they see that your trademark is already there. So they stay away from it. So you don't have to do any work. I mean, your trademark will work for you, and hopefully it will protect you, because other companies will pick another name, because when they see your trademark, they know, okay, that name is already taken. So that's an immediate benefit, but sometimes you don't really think about trademarks like in this aspect. Another benefit is that you have an exclusive right to use your trademark for your products or for your services, like federally in the US or in Canada, like across Canada. So it's not limited to a particular geographical area. Another benefit is that a trademark is a valuable asset. So it increases the value of the assets of your company. So a registered trademark will create a presumption that it's distinctive, valid, and owned by the registered owner. And if there is ever a dispute about the trademark, the burden of proof will lie on the party who is challenging the registered trademark. Because when it's registered, it's presumed to be valid because the trademarks office has already checked you. And last and not least, if you sell on Amazon or if you sell on Walmart, you have to file your trademark in order to get access to brand registry, for example, on Amazon. And Walmart has like a similar thing, like as brand registry on Amazon. So if you want to get access to additional benefits on Amazon, on Walmart, on Shopify as well, so you have to register your trademark. Yeah, and the last thing I wanted to touch base on, in the US, your trademark can become incontestable 5 years after registration. So this will help to eliminate most of the arguments that the owner doesn't have the exclusive rights to the trademark. So that's like so pretty much your trademark becomes indestructible 5 years after registration. So there are lots of benefits, as you can see.
Mm-hmm. I'm curious, just because it came to the top of my head, what happens to a trademark when the trademark owner, I don't know, say passes away or something like that?
Well, if the owner passes away, because the trademark is an asset, you can sell it. You can
Mm-hmm.
transfer it to another entity. Pretty much, the trademark will be owned by the estate. The company can just, transfer the trademark, or they can sell it. So it's not a problem. You can also put your, the trademark in your will. I mean, who will
Yeah.
own it after your death? So I know most people don't think about these things, but you can do this.
No, but just simply calling it an asset immediately gives me answers in my head, just like a lot of different things can be an asset. So I was just kind of curious. So you mentioned the timeline of products being on Amazon and on Walmart. I'm curious, when is the proper time to register a trademark? At what point in that maybe development process is the best time?
Well, it's important to file a trademark as soon as you have realized that your trademark has value in it, and as
Mm-hmm.
soon as you have realized that you don't want anyone else to take your trademark. So I think the question that it's important to ask yourself, would you be upset if you found that another company uses your trademark, or would you be upset if you learned that another company filed for your trademark name?
Mm-hmm.
If the answer is yes, then it's the time to register the trademark. So sometimes it's a little bit early. For example, when you don't know what you're going to sell, what products you're going to sell, when you don't have your business vision completely developed, you don't have a business plan, it's early. Because when you file a trademark, you have to file it for specific products and specific services. You can't just file for the name without anything. So sometimes it's a bit early, but sometimes it's a bit late, because if you procrastinate for too long, it may be possible that when it's time to file, somebody else has already filed for your trademark, and then you are forced to either rebrand, or you're forced to file an opposition,
Mm-hmm.
which is much more expensive than filing a trademark in the first place.
You mentioned the price. I've heard that it isn't terribly expensive. I'm curious both how much, we'll say, a general trademark costs and how long it takes.
Well, the rule of the thumb is to budget at least $1,000 for a
Okay.
trademark. I mean, it can be a little bit less, but usually it's around $1,000. So like $800 to $1,500 on average. And as for the timeline, in the US, it takes 18 months to register a trademark. Canada, it takes 3.5 years. UK, it takes 3 to 4 months. It depends. I think Canada and US are one of the longest jurisdictions for some reason. I don't know
Mm-hmm.
why.
I didn't know it took that long. I mean, that's
Yeah.
remarkable. I'm pretty sure copyrights don't even take that long.
Yes. Well, because in copyrights, they don't really check a lot. When you file a trademark, there are multiple steps that you have to go through. So the trademarks office will check
Mm-hmm.
to make sure that the trademark is distinctive, that it's not generic. They will check for similar trademarks, and then they will either approve your trademark or they will issue an objection. So there are multiple steps that it goes through, and each step takes time. And that's why it takes so long. So it's
Mm-hmm.
not like, okay, you file it and you get a trademark. You file it, you get the number right away, but then you wait and wait and wait.
And this may seem like an obvious question, but like, it's an asset. I get that you don't want other people to, have your name or the general concept of your brand or your idea. But can you kind of go through the process with me a little bit on how to litigate people who try to come after your name or something like that? I mean, Do you just comb through the internet to find
Sure.
that out? I'm very interested in that process a little bit.
Oh, you mean the enforcement, right?
Yes, exactly.
The enforcement of a trademark. Yeah. So first of all, you can only go after somebody after you have registered your trademark. I mean, of course, in many
Mm-hmm.
countries, you can rely on your common law rights. So that is, you have rights because you have used the trademark, but then enforcing those rights are much more complicated. So that's why people register a trademark. It makes it easier to enforce your rights because the rights in your trademark are already presumed because you have gone through the process. So let's presume that you have registered a trademark and then you found that somebody is using a similar like a similar name. How do you already find them? Yes, that's a good question. There are a few ways. I mean, the cheapest one will be to use Google Alerts. You can ask Google to notify you when your brand name is mentioned, and then you will get an email with a summary of like all the mentions of your name online. So that is that's the free method. You can also check Google, every 2-3 months, just plug your brand and see what comes up, and sometimes you will be surprised to find somebody who's using your trademark name. Another option, and that's a paid one, so you can ask trademark company or law firm to do trademark searches for you, so to set up like a watch service or like a monitoring service. We offer that to our clients. So if they want to know when somebody files a new trademark, you can set up a watch service for that, because otherwise when you set up Google Alerts or check online, you will not find newly filed trademarks. You
Mm-hmm.
will only find mentions of your brand name. So it doesn't mean that a trademark was filed. It just means that somebody decided that they're going to use your trademark name or they're going to use a similar brand name. But it's important to know when somebody filed for your trademark, because if somebody filed for your trademark, it's time to get prepared for like a potential trademark opposition. So let's break this up. If somebody just uses your trademark, you can send them a cease and desist letter and tell them that please stop using my trademark immediately. I have a registered trademark and here are the particulars. And if you don't do that, I will sue you. Basically, that's how it goes. And usually it works, especially if you mention a registered trademark. Another instance, if somebody filed for your trademark, so in this case, they may not use it yet. Maybe somebody is just getting ready to use your trademark.
Mm-hmm.
In anticipation of that, they filed for a new trademark and then they're waiting for the trademark to be registered. In this case, you can send something similar to a cease and desist letter. You can send them like a demand letter saying, please withdraw your trademark immediately. Don't ever use it because I have a registered trademark and I have prior rights. And if they don't do that, so let's say they don't comply, then you have to file an opposition. So that's a formal process with the trademarks office. It's like a mini litigation. You basically say, I don't want this trademark to be registered. I object. And then the trademarks office will decide if the other trademark can be registered or not. In many countries, trademark opposition will not even be necessary because the trademarks office will not allow a similar trademark to be registered if you registered your trademark, like in countries like US and Canada and like Australia, China. The trademarks office will stop a similar trademark from being registered because they will do a trademark search and they will see, oh, okay, wait, there is another trademark already. We can't allow you to register your
Mm-hmm.
trademark. And they will issue a refusal. So you will not have to do any work at all. I mean, of course, if the other company is already using a trademark, you will want to tell them to stop using it. So you will want to tell them, please stop using my trademark
Mm-hmm.
or I will sue you. But if there is no use involved, pretty much you can let the trademark office do the work, or you can send them a demand letter, put them on notice that don't try to use this trademark because I will not allow you to do that. But let's say if they don't comply, then you will have to file. So let's say the trademarks office made a mistake. They didn't notice your trademark. I mean, it actually happened with one of our clients. Well, it wasn't a client, but they came to us. The trademarks office missed a similar trademark that was filed afterwards, and they proved that other trademark that was filed after our client's trademark was filed.
Oh, wow.
In
What
that
a
case,
mess.
and because it was past the opposition stage, the trademarks office said, well, we're sorry, we screwed up, but we can't do anything now. You have to go to the federal court and kind of stop them there. But it's extremely unusual when it happens. Usually the trademarks office doesn't screw up. But let's say the trademarks office missed it, or they don't want to withdraw the trademark and they started using it. then the only solution, well, the only way is to actually sue them, because you will not be able to, you can fight them, right? So you can sue them and you can let the court decide, and that will be expensive. And at the same time, so you can sue them, you can also initiate a trademark opposition with the trademarks office. The trademarks office can only decide whether to register a trademark or not. So they cannot award any damages, or they cannot issue an injunction or anything like that. They can only say, okay, this trademark can be registered, or this trademark cannot be registered. That's all they can do. So it's best, obviously, not to go to court, because it's expensive in most countries and it's time consuming, stressful. So yes, monitoring the market, monitoring internet, trademarks office database is very important to do, because if you don't do that, there may be another competitor who filed for your trademark, registered it, used it, and then many years passed. And if you notice a similar trademark too late, even if you decide to sue them, the court may say that you waited for too long. The public has become used to seeing two brands side by side, so we won't do anything. We'll allow you to coexist, and that can be pretty sad. So it's important to monitor the marketplace.
Anita, I'm extremely curious exactly how Trademark Angel gets involved here. Do y'all help give advice on when to maybe enforce something, or like in this example that you referred to, where one company should have gotten their trademark before the other one, but it seems like essentially the trademark office said, sorry, we gave it to these other guys first, even though they were behind you in line. Do you help advise, we'll say, that first company and say, you're better off kind of cutting your losses. They'll have an eight-month jump start for you. So you're better off just kind of like trying to change that brand or that idea and pivoting, instead of spending all that money trying to fight something that you might end up losing. Is that part of Trademark Angel's responsibility?
First of all, we do a comprehensive search before we even file a trademark. We never file blindly. We do the initial search that's free, so it's just to see if there is anything obvious already filed. We tell our clients, please check intranet, check domain names. I mean, do your due diligence on your side, and we'll do the comprehensive search before we file your trademark. So we'll check to see if there is anything out there already filed or registered. And obviously, if we find a similar trademark, we won't file. Recently, we had a client who, well, basically she used your trademark for 3 years, but she never filed. And then she found that there was actually another trademark filed before she even decided to file hers. So, and she got a cease and desist, and she really didn't want to change the name because she invested a lot of money. And I told her, well, look, how much money do you have set up for litigation? And she didn't have any money. Well, maybe $2,000-$3,000. And I said, in this case, it's practically speaking, it's cheaper for you to rebrand now. Just, I know it's painful, and I know you may have prior rights because you've been using it first, but because you haven't trademarked, it will be like very, very expensive for you to prove your rights. So if you don't have, I don't know, $50,000-$70,000, set aside, it's best to rebrand. And before you even rebrand, it's best to enter into coexistence agreement with the other side, just to make sure they don't object, and to make sure they're okay with the new name, and that you can coexist. So they promise not to file an opposition, you promise not to interfere with their trademark, because practically speaking, even if sometimes you're right and you can't prove your rights, I mean, it all comes to the money. Like, how much money do you have? Can you take it all the way? Because we always tell our clients, if you can't take it all the way, don't even start. If you say, okay, I don't want this competitor to win, I will fight it. I'm asking them, okay, how much money do you have set aside? Well, if it's like less than $50,000, we have nothing to talk about, because you will not be able to win, because you can never underestimate the other side. You cannot presume that they're bluffing. I mean, obviously sometimes they are, but you can't make this assumption. Do not underestimate your enemy, your competitor. Always, think about the worst case scenario. And in many cases, people don't have enough money for this, because why would you, spend, $100,000 on, fighting for a brand, unless you're a huge company. And in this case, you probably already trademarked your brand long time ago.
It's more of a defensive maneuver than an offensive one. It's kind of like, and it's definitely a way to protect you and your brand more than it is a way to cut out the competition. I mean, it's kind of really just there to make sure that no one steps on your toes, and that requires a little money up
Exactly.
front if you want to play defensively like that in the business
Yes,
schema.
exactly. That's why we tell our clients, file your trademark as soon as you can, and then monitor the marketplace. Check the trademarks office database so you can stop other people from
Hmm.
diluting your brand. I mean, from using a similar trademark, and you can stop them early. You can even send them a cease and desist letter yourself. I mean, if your trademark is
Hmm.
already registered, you can put them on notice. I mean, it doesn't have to be expensive, but if you don't do anything and the other company grows faster than you, then you
Hmm.
may have a problem because they will have more money to fight you.
Hmm.
And you may, even if you can theoretically win, you will not have the finances. So
Hmm.
it's not always about, who's right and who's wrong. I think it comes down to, who has deeper pockets. I mean,
Hmm.
even if you can win at the end, you may have no money left for your business. So we help businesses with registering their trademarks. We don't actually do the litigation. So we
Sure.
do it's called trademark prosecution. So doing the trademark clearance searches, filing trademarks. We can help with trademark oppositions because that's done like within the trademarks office, responding to trademarks office objections. Basically, transferring the trademarks. So if you need to transfer the trademark to another company. So we can help with all things like that, but we don't actually do litigation because you need to specialize in litigation. We don't do that.
Yeah, that's
Uh,
that's a highly specialized field too, from what I've heard from buddies that
yeah,
are lawyers and do contract law. My cousin actually does contract law, and he said that even to him, trademark and copyright law is highly specific for a lawyer.
yeah, because I mean, the intellectual property law is actually divided into many groups. I mean, you may think it's all the same, but it's not. I mean, patents,
No.
trademarks, copyright, then it's
Uh-huh.
litigation, then it's like franchise agreements, license agreements, like licensing. It's all different types of law,
Hmm.
surprisingly.
Yeah, definitely. I'm curious, what are some things that you can't trademark? We've kind of talked about different occasions where you shouldn't file for a trademark, but what about maybe specific phrases, products, brands, ideas? What can't be trademarked?
Well, a generic name cannot be trademarked. Like, for example, if you sell apples, you cannot trademark green apples. Or if you sell supplements and they help with keto diet, you cannot trademark a name like keto supplements because generic names cannot be trademarked. Like, you should not file a trademark when you are, like, for example, one of the instances when you should not file a trademark if you're just a reseller. So if you resell
Mm,
other people's products and your store doesn't have a unique name, then you really don't need to worry about registering your trademark because you don't have a trademark.
hmm.
Uh, like another instance, if you don't have a unique name, so let's say you sell used cell phones and accessories, and you
Hmm.
operate under the name like cell phones and accessories in Windsor, or like Windsor cell phone and accessories, or Detroit cell phone and accessories. So this is a generic name, so it's not really registrable. Why? Because there may be another Detroit cell phones and accessories also in Detroit, and you cannot stop them from using their trademark because they're also in the same area and they sell the same products. So you can't have the monopoly over like a generic name. You cannot stop other people from using like a generic a generic brand name.
When you mentioned your example of you can't use a generic name like green apples, I thought of Apple. So did they
Hmm.
get away with something that they probably shouldn't have there? I'm curious
Oh,
how Apple trademarked that.
yes. Well, that's like an arbitrary term because they don't sell apples. They sell computers and. So you can sell supplements and call them, I don't know, green zebra, green zebra, because you don't sell zebras, or you don't sell.
No, that's an excellent answer. That totally answers my question because it's kind of counterintuitive to what they sell. It's not like they go around selling apples and
Because
call
there
their
will be
company
no
Apple.
mistake.
Yeah.
Yeah,
Okay.
for example, if you like going back to supplements, so if the supplements name is like keto wellness, keto supplements, keto
Hmm.
green, keto slim, so that's all not registrable.
Hmm.
But if you add something unique, something invented, like, I don't know, fabulicious keto, or like red moon keto, or like, I don't know, cha-cha keto, I'm just creating these words as I speak. So then it will become registrable because this unique word, this made up word, will make an like a descriptive trademark, an unregistrable trademark, registrable. Also, yes, with apples, they don't sell apples. So in this case, it's totally fine.
Wonderful.
Yeah, but if they did sell apples, then they wouldn't be able to trademark. But how did Best Buy get away with registering the name. Yeah, it's Best Buy, it's Best Deal. It's like so descriptive. How could they do that? Because sometimes when you develop a name, especially like some companies in the past, they came up with a name that's very descriptive and they just used it for many years and they grew and they have become really huge. They have become so huge that when you say Best Buy, you immediately think about the store. You don't
Hmm.
think about the best deal. So they have acquired distinctiveness. It's like secondary meaning. So if you have acquired distinctiveness to a point that everyone, well, probably in the US or in Canada, for example, will think about you rather than like something else, then you can register a trademark that's descriptive. But you have to be really big. So you have to have sales in every state and you have to have sales like for at least 5 years.
Hmm.
But otherwise, you can't really, it's very difficult to register a descriptive trademark or like a generic trademark. In the US, you can register a descriptive trademark, but it will be registered like in a special place called supplemental register. It's like a
Hmm.
special waiting room for weak trademarks, like descriptive trademarks. So I won't go into many details, but I mean, it's possible, but it doesn't give you all the rights, but it's better than nothing. So if you have a descriptive name that you cannot change, there are actually a few strategies how you can trademark that. You can add a logo, you can add a unique picture and register the whole thing. So you can register a descriptive phrase plus the image all together, like a combined image, or you can add a unique word, or you can register a descriptive trademark on the supplemental register and then wait for 5 years and then re-register and claim acquired distinctiveness. So it's
Hmm.
possible, but it's a bit complicated. But it's best to pick a name that's not descriptive.
That provides a good opportunity to ask about logos because to my knowledge and to kind of what you mentioned at the top of the episode, this may be totally
Mm-hmm.
wrong. Logos are more creative decisions in terms of like art. So wouldn't that be more of something that you'd want to copyright, or do you trademark logos as well?
Yeah, actually, you can do both. You can copyright to protect the creative part of the logo,
Okay,
and you can also trademark the logo if the
interesting.
logo acts as a source indicator. So, well, what do I mean by this? So if I'm looking at your logo and I immediately think about your product, in this
Hmm.
case, the logo is pretty much this. It's a trademark too.
Hmm.
So you look at the Starbucks logo, well, you look at this lady, and you immediately think about them. You don't have to see
Hmm.
the text Starbucks, okay, that's the coffee place, right? So you go there and you don't need to read anything. So in this
Hmm.
case, it's a source indicator. So okay, because if you go to that place, you can buy coffee. So you can register a trademark, but you can also you can also protect it by copyright. So there are two
Hmm.
forms of protection here. I mean, copyright registration is not really necessary because you own copyright from the moment you create something that's artistic or that has some creation in it, creative aspect. So you own copyright. You can register copyright to claim additional damages, like if somebody used a similar logo, like a similar picture as you did, or like if somebody infringed on your copyright, but you don't have to. With trademarks, it's advisable to register because there are so many additional benefits. And trademarks are searchable, but copyrights are not really searchable easily. So that's like another huge difference.
Hmm.
So you can't easily check if copyright is registered with the Copyright Office. But if you see the copyright symbol, you can make a presumption, okay, that's like
Hmm.
somebody's copyright, they created this, so I should stay away. So if you
Hmm.
see the C in the circle, so that's copyright symbol.
Sure.
So stay away from that. We advise our clients not to trademark logos that are created by platforms like Canva, that help you to, create your own logos or your own pictures because
Oh,
you
Canva. Yeah, yeah, yeah.
yeah,
I
Canva,
understand.
yeah. So
Uh-huh.
it has to be, if you want to have a completely unique logo, you should design it from scratch.
Hmm.
You should hire a designer to design the logo from scratch. And guess what happens after the logo is created? Who will own copyright in the logo
Hmm.
after the designer created for you? The designer, because he created the logo.
Sure.
So if the designer didn't transfer the copyright to you, he will continue owning the logo. We actually had a very funny, but I mean, it wasn't funny for the client
Yeah.
when we filed a trademark for a logo, uh, and we later found that it's like a similar logo was already actually registered by somebody else because the designer sold the same logo twice.
Oh
because
no.
our client didn't have the copyright in the logo transferred to him. So it's like a good tip. If you hire a designer to create a unique logo for you, ask him to transfer the copyright in the image to you. And it's very simple. You just say, okay, the name of the designer, transfer the
Hmm.
copyright in this logo, put the logo, and to you, the name of the buyer, and date and sign. That's it. And then he will not be able to resell it, because it was like very frustrating when we actually found out that the same logo was pretty much reused and
Hmm.
sold twice. But many designers don't just know this.
No, no, and their focus is a lot more on the creative, and some are obviously very business savvy. Don't get me wrong, but to my knowledge, the brand and the company, and in this case, the client, would most likely, in addition to the product that they're getting, which in this case is a logo, they'd
Mhm.
also probably have to pay the artist for those copyright. They're not just going to kind of give away a copyright, right? I mean,
Well, actually, you should agree to this before the work starts. I mean, many big
sure.
companies, it's already in their like agreement that copyright is owned by the buyer. But if you
Hmm.
hire somebody privately and you already pay the money, and then you ask them to transfer copyright, yes, they may charge you for that. So you should,
Hmm.
talk about that beforehand, before you paid the money, before you
Hmm.
actually hired them. Because yes, if you work with somebody cheap, like for example on Fiverr, yes, they may charge extra for that, because they will see
Yeah,
it as a good opportunity to, get some extra money. But
yeah.
big companies, if you work with big designers, like the Logos Designs 99, I think it's called, they will by default transfer the copyright to you. You don't have it. You don't have to ask.
No, that makes a lot of sense. I'm curious about, you mentioned the copyright symbol in and of itself. One of my questions I have here is about the TM symbol and maybe the
Mhm.
difference between, a registered trademark like the little R symbol that you see on the bottom versus a
Yes.
TM symbol. When do you use what? Can you use it whenever, however? Could you kind of explain that process a little bit? Because
Yes.
I see it and people love to put it like even in
Yeah.
emails or something where it's proprietary information.
Well, I don't think people actually understand the significance of this. So if we'll talk about the US, and then I'll briefly mention Canada. So it doesn't need to be filed or registered. You can just put TM, and it means, okay, I use this name as a trademark.
Mhm.
So you put TM in superscript. It just means, okay, I use this brand as a trademark, as a source indicator, nothing else. It doesn't mean anything else. You can only put R in a circle after you have registered your trademark in the US. You shouldn't put R in the logo, in the circle, before registration, because there is like, they can be fine and even like prison, but
Oh
it doesn't
wow.
doesn't well, they say, but I don't know anyone who's been jailed for that. But
Yeah.
you should not put R in a circle. Like in Canada, there are no marking requirements. I mean, there are suggestions, the same as like in the US. So put TM at any time when you think you use a brand as a trademark, and put R in a circle after registration. My advice is to put TM if you use your trademark as a brand, and put it once. Put it in the first instance. Don't put it like every time you mention your trademark. It looks silly, to be
Hmm.
honest. And you just get annoyed when you see TM everywhere. And you can put R in a circle only just once in the first instance, and then you can how you can show your brand, how you can show your trademark. You can put it in bold, you can put it in all caps, you can put it in italics, so that
Hmm.
it stands out. So your brand name, your trademark, has to stand out from the text in
Hmm.
any way that you like. Caps, italics, bigger font, or TMOR in a circle. It's just another way of showing, hey, this is my trademark. But there are other ways to show that by, putting your brand in all caps, for example. So that's like
Hmm.
an easy way. Put it in bold, put it in italics, and people will know, okay, so this is a brand name mentioned here. So
Sure.
that's cool. But I mean, people are not stupid, but sometimes when I see TM mentioned everywhere, I just think, okay, this company obviously thinks that I'm stupid, because they mention this every time. So it's a bit excessive, but
They're trying to do like
everyone,
sleight of hand a little bit. Yeah.
yeah, you can put TM, and then, in the footnote, you can put, okay, this brand is a trademark of this company, and that's enough. I mean, people can read if they want to, so you don't have to mention it every time. So, I mean, just put it once, or you don't have to put it at all. If you think it will look ugly or interfere with your text, you don't have to put any symbols, actually.
Look, Anita, I could talk about this stuff for hours, but before we go, I always ask my guests one final question. In the e-commerce industry, it can be
Hmm.
very high anxiety, stress inducing. I'm curious, what are some of your healthy coping mechanisms in terms of hobbies and interests that keep your work life balanced?
Oh, learn early to delegate your work
Oh,
to other
nice.
people, because for me it was the lifesaver. Because when I started the business, I immediately hired an assistant because it was just getting unmanageable very early, and I was burning out. I was working 60 hours a week and it was not manageable.
Mm-hmm.
So if you learn how to delegate, your life will become easier. You can write manuals, you can just record a video for your assistants, and believe it or not, I mean, it's actually very pleasant to delegate because you can clone yourself, you can multiply yourself.
Yeah.
Like right now, I have 15 people in my company, so I can travel and I can work, reasonable hours, and the work is still done by other
Mm-hmm.
people because people are smart. I mean, never underappreciate or underestimate that other people are also capable to do what you are doing because you're not irreplaceable.
Mm-hmm.
So I learned how to delegate, how to trust people. You should have some trust in your employees, in your staff, in your subcontractors, and give them some freedom. So for example, my subcontractors, my employees, they can work any hours they like. I mean, there are absolutely no rules. Like, you just do your work when you want. You have freedom.
Mm-hmm.
So they appreciate this, and I mean, actually, we don't have any turnover. People stay, and actually, most of my employees and my subcontractors, I mean, have been with us, I mean, for the whole like 5-6 years, because they like this. I mean, they're independent. I mean, it's like their own little business because they have freedom when to work, like what hours to work, and like I don't breathe down their neck.
Mm-hmm.
I also, like, another tip I learned, I actually figured out for myself. I hate company meetings, those like huge meetings when you discuss, like Monday meetings. We used to have Monday meetings in my in a law firm where I worked before. It's like for 45 minutes, you just sit and listen to something that doesn't have any relation to you, and just waste your time. And for me, it's just like the time that I pay for that absolutely brings no benefit. So we actually don't have any meetings at all. I can have like a meeting one-on-one, or we can just, you just write notes. It's much more efficient than,
Mm-hmm.
just having a huge meeting, and, most people just, they do other things while you talk. So yes, those are the two tips I think that I have.
They're great tips, honestly. Thank you so much for your time, Anita. Good luck to you and Trademark Angel.
Yes, no problem. Nice talking to you. Thank you very much.
I'd like to thank my guest, Anita Marr, for joining me on the show, and come back next time when I talk with Noah Tucker, the founder and CEO of Social Snowball, an affiliate and referral marketing platform for e-commerce brands. For more information about Anita, you can connect with her on LinkedIn. To learn more about Trademark Angel, you can visit their website, trademarkangel.com, or follow them on Instagram at trademark.angel or on Facebook at trademarkangel. That's our show. Thanks for joining us, and we hope you come back to find more insight from the top experts in the e-commerce community. Until then.